The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer the question, are contracts valid if they aren't in writing? We're going to first talk about the validity of oral contracts and when contracts do have to be in writing in order to be enforced, and then we're going to talk about how to prove an oral contract. So first, are oral contracts valid? The answer generally is yes, as long as you would meet the requirements of any valid contract. Oral contracts are just as valid as a written contract. So the requirements of a contract are offer, acceptance, and consideration. Offer and acceptance basically go together. They mean that one party made an offer to do something, the other party accepted that exact offer without making a counter offer. So it's not, yes, I accept your offer, but you have to add this to your offer. It's, yes, I accept your offer exactly as stated. So that's offer and acceptance. And then consideration is the benefit that both sides have to receive some benefit from the contract. And we have a whole video on what qualifies and what doesn't qualify as consideration at learn-about-law.com. So yes, generally oral contracts are valid, but proving an oral contract is much more difficult than proving a written contract, both proving that it exists and also proving its terms. So we'll talk about how to prove oral contracts in a minute. But first let's talk about the types of oral contracts that aren't valid, that need to be in writing in order to be valid. So there's something called the Statute of Frauds, and it lays out 8 different types of contracts that need to be in writing in order to be enforceable. One is a contract involving the payment of another person's debt. Another is a contract that has a longer longevity of the performance of the contract than the life of someone named in the contract. Leases lasting for more than 1 year. Contracts with value over a certain threshold that varies from state to state. Contracts for the sale of real estate. Contracts to transfer property to somebody else when the owner dies. Agreements made between executors of an estate and anybody else. And then contracts for the sale of goods, non-real estate, totaling more than $500. So in those 8 situations, you have to have a contract in writing signed by both parties in order to be valid. Let's next talk about how to prove an oral contract. So if you do have an oral contract and one side breaches it, like I said, it's much more difficult to prove than a written contract, both that it exists and what its terms are. There's 3 basic ways to prove an oral contract. One is the testimony of a third-party witness that saw the oral exchange and saw the contract happen. Next is the credibility of the party. So this is just kind of a he said, she said situation where you take the credibility of one party against the credibility of the other, and whichever the court determines to be more credible will win. Third is course of conduct, and this is both parties acting as if the contract exists as the person alleging the contract stated it did. So if it's a contract to buy a certain amount of goods from somebody else and the goods were delivered and payment was never made, that's a good indication that the contract existed. But it's got to be both sides acting in a way consistent with the contract. So if I just deliver some goods to somebody and say, now pay me due to our oral contract, if that person never acted in a way consistent with the contract, that's not going to fly. So it's got to be both parties acting like the contract existed after the fact. If you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below our video on our YouTube station. If you found this helpful and you'd like to subscribe, we would love you to. Subscribe to our YouTube, iTunes, and SoundCloud station to get updates about our daily article and video topics. Or you can subscribe to our email database at learn-about-law.com, and you'll get a email blast once a month that lays out some of our best articles and videos for you to just click on. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We have offices all around Chicagoland, and we offer free consultations in many areas of law. Thank you so much for watching.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.